The enforcement landscape of U.S. privacy and security laws is complex and multifaceted, involving various mechanisms and entities, from criminal and civil liability to self-regulatory enforcement. This video essay explores the diverse facets of enforcement, elucidating how they collectively contribute to the protection of privacy and security in the United States. Criminal versus civil liability. In the context of privacy and security laws, enforcement can either take a criminal or civil liability form. Criminal liability involves the government prosecuting violations that entail illegal activities, such as unauthorized access to systems, hacking, or identity theft, leading potentially to imprisonment or fines for the individuals involved. Civil liability, on the other hand, allows individuals or entities to seek redress for breaches that affect them, often resulting in monetary damages or orders for corrective actions. General theories of legal liability. The enforcement of privacy laws in the U.S. is grounded in several legal theories, each providing a basis for liability and redress. Contract. Breach of contract claims arise when one party fails to honor the privacy protections promised in a contract, such as terms of service or privacy policies. Tort. Privacy violations may constitute torts, such as invasion of privacy or negligence, allowing affected individuals to seek damages for harm suffered. Civil enforcement. Regulatory bodies like the Federal Trade Commission, FTC, enforce privacy laws through civil actions, imposing penalties and requiring corrective measures for non-compliance. Negligence. Negligence plays a significant role in privacy law enforcement, particularly when an entity fails to take reasonable measures to protect personal information, leading to unauthorized access or breaches. Entities may be held liable for damages resulting from such negligence. Unfair and deceptive trade practices, UDTP. The FTC uses UDTP laws to pursue companies that fail to protect consumer privacy or mislead consumers about their privacy practices. This enforcement mechanism is crucial in holding companies accountable for their privacy promises and practices. Federal enforcement actions. At the federal level, various agencies, including the FTC, the Department of Health and Human Services, HHS, and the Securities and Exchange Commission, SEC, play pivotal roles in enforcing privacy and security laws. Their actions can include investigations, settlements, and litigation to enforce compliance and protect consumer privacy. State enforcement. State attorneys general, AGs, and specific regulatory bodies like the California Privacy Protection Agency, CPPA, are increasingly active in privacy law enforcement. They can initiate investigations, bring lawsuits, and negotiate settlements, often leading the charge in addressing privacy violations affecting their constituents. Cross-border enforcement issues. With the proliferation of digital data flows across borders, entities must navigate complex international privacy regulations. The Global Privacy Enforcement Network, GPN, facilitates cooperation and information sharing among privacy enforcement authorities worldwide, helping to address cross-border privacy concerns. Self-regulatory enforcement. Self-regulatory frameworks, such as the Payment Card Industry Data Security Standard, PCI DSS, and various trust marks, play a complementary role in privacy enforcement. These frameworks set industry-specific standards and provide mechanisms for certification and compliance verification, enhancing privacy protections through market-driven incentives. The enforcement of U.S. privacy and security laws is characterized by its layered and diverse approach, incorporating both public and private mechanisms. This multifaceted enforcement landscape ensures that privacy protections are adaptable and robust, capable of addressing the evolving challenges of the digital age. Other key considerations for US-based global multinational companies. GDPR requirements. The General Data Protection Regulation, GDPR, sets a high standard for data protection and affects US-based companies processing the data of individuals in the EU. Compliance requires a comprehensive approach to data protection, including rights for individuals, data protection impact assessments, and strict data processing principles. APEC Privacy Framework. The Asia-Pacific Economic Cooperation, APEC Privacy Framework, provides guidelines for ensuring privacy and data protection across the Asia-Pacific region. US-based companies operating in this area must navigate these principles alongside other regional and national regulations. Resolving multinational compliance conflicts. EU data protection versus e-discovery. Reconciling EU data protection requirements with US legal obligations for e-discovery presents a challenge for multinational companies. Balancing the need for data access in legal proceedings with the protection of personal data requires careful negotiation and adherence to legal frameworks that facilitate such transfers. Conclusion: navigating the US privacy environment requires a sophisticated understanding of both domestic and international data protection landscapes. As digital technologies continue to evolve, so too do the challenges and opportunities for privacy management. By adopting comprehensive privacy programs, fostering a culture of accountability, and remaining vigilant in the face of cyber threats and regulatory changes, organizations can not only comply with legal requirements, but also build trust with customers and stakeholders. The intersection of legal compliance, technological innovation, and ethical considerations in the management of information underscores the importance of a proactive and strategic approach to privacy in the digital age.